Right, I now call the meeting to order. Let's elect the chairman. Any proposal? Mr. Tam. I nominate Mr. Dennis Kwok. Mr. Kwok, do you accept the nomination? I second. All right, I now declare Mr. Kwok elected as chairman of the subcommittee. Shall we invite the administration in, please?
Regulation 你有冇咩 comment？ 冇乜特別嘢。OK 啊 ，OK。係啊，應該得㗎啦。冇問題，你放心。都冇人嚟，你睇下。譚 Sir 都走埋。
譚 Sir 隔離幼稚園啊。
幼稚園緊要啲。
我哋而家出晒 page， 再 remind 啲會員。
早晨。早晨。
Good morning.
Good
morning. Madam Fong or Mr. Laurie Lowe, Deputy Secretary for Home Affairs. Thank you, Chairman. Today we're dealing with the legislative amendment regarding the assessment of resources and contributions amendment regulation. The spirit of legal aid is that those with a reasonable ground for legal action should not be denied any access of justice because of lack of means. The legal aid system is funded by taxpayers' money, so there is a contribution arrangement depending on one's means. There is a need to pay a contribution to the legal aid in accordance with the resources bandwidth. And if they are below a certain level, they don't have to pay any contribution at all. As regards what resources bandwidth one has to pay the contribution, there is a scale of contribution. All the details are set out in the schedule of the legal aid regulation, and that is we do have the bandwidth contribution and in accordance with the FEL. At the moment, it is on the basis of absolute dollar figure, but the resources bandwidth will change in accordance with the CPI, and the financial eligibility limit has changed in accordance with the Consumer Price Index. If I may refer members to Parent 9 of the paper, there are certain bandwidths where there is no further room for upward adjustment, and there are certain bandwidths where the distribution between the bands is so uneven. So the purpose of this amendment is that instead of making adjustment all the time. It is more fair to represent the resources bandwidth in terms of percentages of the financial eligibility limit, and the contribution made by the aided persons will be in terms of percentages. Now, at the moment, there are some resources bandwidths are so close to the financial eligibility limit that we cannot make any upward adjustment, and this will also address the problem of uneven distribution of the resources bandwidth. Today, if the bandwidth is over $20,000, one has to pay the contribution. If we are going to represent this in terms of percentages, then under the OLAS FEL, if it is more than 12.5%, one would start to have to pay the contribution. So if we use the 2013 figures, of the 10,000 aided persons, 72% had to pay the contribution. As a result of the changes, using the same set of statistics, 78% of the people don't have to pay the contribution. For the first two bands, they are represented in absolute dollar terms, $1,000 and $2,000, and in the light of the same spirit, if we link it with the FEL, then we will be able to maintain the even distribution. The proposed change will not result in anybody paying more contribution. There will be more, in fact, who don't have to pay any contribution at all. For those who are paying contribution, because of the changes to the bandwidth, more people will pay less contribution. Even for those who are close to the FEL, they will pay the same proportion of contribution as it is today. So that's basically the change that we are proposing. As a result of these changes, the calculation of the contribution made by the aided person will be fairer, and this will address the problem of not being able to make any upward adjustment because of the existing problem, and this will be adjusted in accordance with the Consumer Price Index. I welcome any questions members might have. Mr. Albert Ho. Chairman, Deputy Secretary, will you give us some specific examples in relation to the inability to make any further upward adjustment? I don't think I'm with you. You might have explained before, but I don't quite remember. Can you fill us in on the details, please? If I may refer members to the paper, para 9. I am referring to the LegCo brief, LegCo brief, para 9, H and I. This is the current arrangement. For most of the bandwidths, they are expressed in dollar terms. In H, 144,000 to the ceiling, and this is in accordance with the OLAS FEL. Now this OLAS FEL is adjusted over the years upwards. In H, from 144,000 to the OLS, ASFEL, the gap is getting bigger. But if you turn to I, the OLAS FEL was the lower tram line. The upper tram line is 269,700, and now the ceiling is 269,620. There is only a difference of $80 between the upper and lower tram lines. If even if we adjust it upward by 1%, it would go beyond the figure on the right-hand side column. And in fact, the inflation has been more than 1%. If we do not resolve these technical constraints, we will not be able to adjust upward the OLAS FEL. On one side, we have the absolute dollar figure, and on the other side, we have a figure which is adjustable. Well, the other thing is, if I may refer members to para 11, if you look at the table at the bottom of the page, H and I, now this is expressed in percentage terms for the different bandwidths. A to G for the lower figure, we're talking about 7 to 8% within a band. As a result of the adjustment of the FEL, in H, it covers the 53rd to 100th of the bandwidth. Covers 47 percentage points. In I, the same problem appears with the FEL changing, whereas the cap doesn't change, and this results in the distribution of the bands being so uneven. As a result of the changes previously, each band covers about 11 or so percentage points, and now we are proposing 12.5% for each and every band, and that would enable the distribution to be more even, because that would have a knock-on effect on the percentage of contribution one has to pay.
Chairman, for OLAS on its FEL, now there's no change, right? But it's adjusted every year. We don't necessarily have to change it every year. However, we would look at the inflation rates in the past period, and then we will put forward a suggestion for upward adjustment. Now we have looked at it again, and it's 2 years after the last adjustment. And during this period, the inflation rate is about 7.5%. So we are planning to adjust upwardly the FEL for about the same percentage. But if you look at H and I, there may be a problem, because the ceiling of the band may be reached. Now, if you're going to do this, under some circumstances, the FEL will catch up with the ceiling of the next higher resources band. So now you are making this adjustment, and the contribution will be lowered. Yes, in simple terms, most of the aided person would have to pay less. In the past, if they didn't have to make contribution, now they still don't have to make contribution. And for some other people, according to the past system, they may have to make contribution, but now with the new system, they don't have to make contribution. If we use the 2013 figure, the percentage will be increased from 72% to 78%. That is, those APs who do not have to pay. So after adjusting the bandwidths, if we look at the present system, most of the AP would have to make less contribution when the new system is in place. And some of them may fall under the same bandwidth, and they may have to make the same contribution. Well, in most of the cases, many people would not have to pay, and for some who had to pay in the past, now they don't have to pay. So there will not be any people who would have to pay more. I think this is quite clear. The government will have to pay more. After making this change, I can see that the government would have to spend more on these schemes. I understand that the government has a lot of schemes. So why is the legal aid system so complicated? How come when it was formulated, it was so complex? Now it's still very complicated. What's the thinking behind that? There are two questions. Well, is the government going to spend more on this? I think we have to look at it from two angles. If we just look at the calculation, it is possible. Well, maybe let me put it this way. Now, for the legal aid concept, we have to look at things when a case is closed. Now, the the aided person would have to make his contributions, and that's the ceiling of the bandwidth. But that doesn't mean that the government will take all the money. We will have to look at the judgment at the end, whether damages will be made, where he would have to foot the cost, etc. So we have to look at all these factors before we can calculate the amount that the aided person has to pay. Now, according to the table, he has to pay a certain level of contribution. However, when the judgment is made, then he may be able to claim costs from the other party, or he may be able to keep some properties or money. So all this would be taken into account at the final calculation. So for this, all these damages and costs will be taken into account, and the balance will be refunded to the AP. So for each and every case, as to how much contribution the AP would have to pay, we would have to look at how much the LAD has spent and how much cost can be recovered from the other party, etc. So if we just calculate according to the above information, and if we look at the 2013 figures, the LAD will be getting $15 million less with the new system. But of course, we will still have to look at the cases themselves. We will be getting less. However, we will have to look at the final rulings, and then the amounts may change because damages and cost are involved. So if we are just looking at this amendment, we cannot tell you how much the government is going to pay more or less. Why was the system so complicated? It's very difficult for me to guess why they formulated such a scheme. Well, when this scheme was first introduced, if you look at Annex B, which is the existing regulation. If you look at Part 1, Paragraph B, the table is exactly what I talked about just now. At that time, they used exact dollar figures. And for the financial resources, is actually set at a amount not too far away from the figure of 144,000. And if you look at column B, the amount of financial resources specified in section 5 bracket 1 of the ordinance. Well, because this is the figure, this is the only figure that would change, and all the other figures in this table will not change. So after a certain period of time, in particular in 2011, we made a major upward adjustment to FEL. So that's why today we have this problem. That is, if we do not make a change, we cannot increase the FEL level anymore, because there would be a problem of logic. So today we are making this amendment because we want to solve this problem for the long run. We will not be using absolute dollar figures, and the resources bandwidths will be represented as percentages of the OLAS FEL. So we don't have to come back in 10 years' time to make another adjustment to the whole table. We are now trying to tackle the problem at root. And when the table was first introduced, there was a rough design of distribution, and now we are trying to go back to that. Mr. Ho? Chairman? Well, Chairman, I'm not too familiar with this kind of computation. I hope the Deputy Secretary can be patient with me. For the LS report, paragraph 2, it mentioned the old figure of 269,620, and it says that for the OLAS, it would not exceed $1,348,100. However, when the Deputy Secretary explained to us just now, he hasn't told us how this ceiling will be changed in the future. So would they change it in accordance with the Consumer Price Index? Or as the old figure, 269,620, is a solid figure, and you have to change the law in order to change it? Well, maybe I should explain about one more point. Just now I mentioned the OLAS FEL 269,620. That is when an applicant, now let's say he's passed the merits test, and if we look at his financial resources, if within a 12-month period his disposable income and disposable capital exceed this figure, he cannot get legal aid. However, if the case is about human rights, or if it's a criminal case, if the director of legal aid thinks that the case should indeed is indeed meritorious, he may also offer him legal aid. So even though his financial resources exceed this level, he may still be able to get legal aid. However, the aided person would have to make contribution. So if you look at the table, well, please look at paragraph 11. It is about the actual operation of the LAD. You can also refer to paragraph 9. They set out that under such circumstances, some aided person may have financial resources that are exceeding the OLASFEL. However, maybe it's for justice, or maybe it's the decision of the director of legal aid. He may still be able to get legal aid, and he would have to make contribution. So for our proposed amendment, we are using the same method. That is, we will use percentage. After the amendment, percentages would still be calculated in accordance with the FEL. However, there are problems with the present table, because in some areas we use absolute dollar figures, in other areas we use percentage points. So that's why there are a lot of problems. Chairman, I still don't understand. Can our legal advisor explain to us? Just now, the Deputy Secretary mentioned paragraph 11. And for bandwidth Q, is more or equivalent to $1.2 million. For our LS reports, paragraph 2 is 1.3481 million. So what's the relationship between the two? Well, for the $1.348 million is about the SLAS. That is, if the aided person has assessed financial resources exceeding $269,620, then he would be subject under SLAS. As the administration mentioned just now, human rights cases will fall under this category, even though the person's financial resources are above the OLASFEL, but still under the SLASFEL, then he would still be able to get legal aid. For paragraph 9 and 11 of the LegCo brief, we can see these two tables. For 1.34 million, the base, and if the base figure is 269,620, then the 1.3 million is about 5 times of that. I have a question. Well, I would like to declare my interest. I am involved in some legal aid cases. Now, for this amendment, I think the direction is right. However, for SLAS, I understand that the government is now reviewing it. Can you tell me about the progress of the review? Thank you, Chairman. Well, for SLAS, in 2012, we expanded its coverage. We understand that the profession and the LegCo hope us to expand the scope even more. So now we are conducting another review on the scheme. The legal aid commission is now looking at that. We understand that the Bar Association and the Law Society are asking the the Legal Aid Council to look at this. And the two legal professional bodies will be consulted. Thank you, Chairman. According to our information, now they are preparing the report for the government's consideration. In March, they had a meeting, and the administration has informed the Legal Aid Services Council that the two professional bodies would want to express their views, so they will follow up on this.
We hope that the report will become available soon, so that we know more about the SLAS. Mr. Lee Chang-yan, I'm looking at the table merely from the logical point of view. It should be 0 to 50, we did the mathematics questions. 5, 10 should then be 15. 0, 5, 10, 15. Now these $1,000, $2,000. It doesn't make any much difference, but for the low-income people, you should adopt a more logical band. It would be easier for people to remember. 0, 5, 10, 15 is far easier than 12.5, starting with 12.5%. Did you ever consider a more logical banding system? Deputy Secretary. First of all, the lowest two bands for contribution to be made, we have $1,000 and $2,000, and they're expressed in absolute dollar figure. This 1,000, 2,000, if you compare this with the FEL for the 20 to 40,000 bands, they're paying $1,000, $2,000, and there's about 2.5 to 5% in percentage terms. 40,000, 60,000, they're paying 3.3 to 5%. So our proposal is to make sure that the person with certain financial means should be made to pay certain contribution. As the purchasing power changes, then the internal logic would disappear. So we are proposing that we link it with the FEL in terms of percentage. This 2% and 5% were adopted by comparison with the percentage from the $1,000 to $2,000. Now $20,000 to $40,000, they're paying 2.5 to 5%, and for the first band it is at 2%, and for the next band we're proposing 2.5%. Previously it was 3.3%. We are using a percentage of the FEL, 12.5%. Those who don't have to pay any contribution previously, if the assessed resources exceed $20,000, they don't have to pay. But in future, it's only when they exceed $30,000 that they have to pay. For those paying $2,000, if the financial resources are $40,000, then they're paying $2,000. And it's only when they exceed $67,000 that they have to pay in accordance with 2.5%. There is a higher bandwidth and a lower percentage. So the whole arrangement is intended to look after those with limited financial means. But in accordance with the legal aid spirit, they will have to pay contribution in accordance with the scale. Let's say in the first band, $1,000 payable. It's only when they are at $33,000 and $67,000 that they have to pay, and the difference is $600 to $1,300. For $60,000 and above, they're paying $2,000. In accordance with the new proposal, $60,000 would move to the first band, and they're paying 2%. If we use the 2% they're paying something like $1,000, less than the $2,000 that they're currently paying. Those with the same FEL, they will drop down to the lower percentage. And in future, as I said, 78% of the aided persons of legal aid don't have to pay any contribution at all in future. Mr. Tenkabu. Chairman, thank you. I'd like to seek more clarification for human rights cases. If the DLA finds the case meritorious, then even it is more than 500%, the illegal aid will be granted, but there is a capped 67% contribution. Let's say one goes up to 500%. How much the contribution does one have to pay? If one exceeds more than 1,000%, how much contribution does it have to pay, or would there be any ceiling? For 1,000 or 10,000 cases, how many of them are CSSA recipients? As you're aware, under 8A, there is a particular arrangement. I'm wondering whether you have collected any statistics there. There are certain cases that tend to seek legal aid, like employees' compensation, and also the personal injuries. Have you found out from the judiciary how many of these cases are legally aided? And what impact would there be if one is granted legal aid or not granted legal aid? Let me take the first two questions first. I defer to the legal aid for the third question. As regards the ceiling, we're talking about the contribution percentage. The higher the assessed financial resources, then the contribution will be higher. So the actual actual sum of contribution will not be subject to any ceiling per se. So there may come a point, you may be able to work it out. We're talking about 67% or 2/3 of the assessed financial resources. If someone is of very good financial means, then they won't come to this scheme because they will have to have 2/3 of the resources assessed. So at a certain point, people will not come to legal aid for assistance, and they may be retaining their own lawyers, and the fees that they pay will not be higher than this. Now here, at the highest band, 1.2 billion and above, at today's calculation, 1.2 billion for the assessed financial resources. If we adopt 67% of contribution, they have to pay $804,000. Under the new arrangement, if they hit 500% of the FEL, then the sum is $1.348 million. Using this 67%, they have to pay $903,000 up front. Now this is what they have to pay up front in accordance with this calculation. And this is the ceiling one has to pay in this case. At the end of the day, whether he will be able to get back the money will depend on the outcome of the case and the costs of the litigation, and whether there will be any costs recoverable from the opposite party. And we will have to take into account these factors before one can work out the contribution. If someone needs legal aid and he has to pay $900,000 up front before the legal aid will be activated. Is that right? Yes, this is the normal situation. In certain circumstances, if the aided person experiences financial difficulties and subject to DLA agreement, this can be paid by installment. Let's say at the end of the day, the sum comes to, let's say, $600,000. What's going to happen to the money? Well, there will be a refund. On the second question is about perhaps I defer to the legal aid department. I beg your pardon, the second question about the CSSA recipients. Under the arrangement, unless there is other evidence that makes the DLA think otherwise, a recipient, CSSA recipient, doesn't have to pay anything. In 2013, you talked about 10,000 cases. Yes, I defer to the legal aid department. Mr. Tang asked the question about CSSA recipients. I don't have any figures with me about how many CSSA recipients receiving legal aid. But according to our information, each year, 80% of the cases would pay contribution of $2,000 or below. Most of them don't have to pay any contribution. And this figure includes the CSSA recipients as well. Mr. Tang also raised another question about marital cases and personal injury cases. How many cases are assisted by legal aid? I don't have the figures in this regard, but I can say to Mr. Tang that in terms of the cases received, 2013, 2.3% fall into the category of personal injury and marital cases, and 90% of the certificates issued are in relation to these cases. Each year, let's say we grant 10,000 civil cases, about 8,000 cases are related to personal injuries or marital cases. Ms. Sitho, second round. If I may put a question that may not be directly relevant to the amendment, but it is in relation to the assessed financial resources. Now, there may be some insurance policies, the cash value will be included in the assessed financial resources. Will the government consider revising the formula and exclude the cash values of the insurance policy? There is no universal retirement protection. Many people are saving up for retirement by taking out insurance. Let's say a worker, not so much the middle class people. If you exclude the cash value of the policy, he may come under the 10,000 category. But if he has an insurance policy $300-400 per month, and he may, the insurance cash value may come to $200,000, and he will jump to the $140,000 to $260,000 band if the cash value of the insurance policy is included.
But the government is encouraging people to take care of their own retirement protection. So if the life insurance policy is also calculated, then this would discourage them. And even for MPF, they cannot get their accrued benefits for this purpose. So if they are paying for their own retirement insurance, why do you have to take that into calculation? So I hope that when you assess their financial resources, insurance policies should be taken away. Now, if we look at Band 3, 60,000 to 80,000, if the cash value of the insurance policy is about 100,000, it's actually a very humble amount. But if that is the case, he will be elevated to another bandwidth, and he would have to pay $20,000 more for the litigation. This will be a major burden on the aided person. Now, the government has come up with this MPF system, and people cannot withdraw their accrued benefits if they have a court case to take care of. And now you're saying that the retirement protection is very important. So how come you are adopting this policy? I think the concept is like this. The government does encourage people to make arrangements for their retirement life. Now we have the MPF system, and people can also prepare for their retirement through other means. You can decide to put your surplus money in the bank. You can buy some more stable stocks. These are long-term investments for retirement. So in terms of concept, it is very difficult for the government to distinguish. That is, if you invest in an insurance policy, why you can be exempted, and if you invest in the stock market, you will not be exempted. Now, we are not taking the MPF into account. However, for other investment tools and retirement arrangements, it seems that there are not enough justifications for one of these investment tools to be exempted. Now, if the government will launch a universal retirement protection, then I think I can accept that. But now we don't have it, and people have to plan for their own retirement. Well, MPF is just a bit better than CSSA. Now, if your income is high, then you may not think that is a problem. But for the grassrooters, they may be saving several $100s for their life insurance each month, and it's already very difficult for them. Now, if a person is paying for a life insurance for 30 years, and after 30 years he's getting a little bit of money, he would get more if he invests in life insurance than putting the money in the bank. So I think you should really take this into consideration. Even though insurance policy cannot be exempted, maybe you don't have to calculate the amount 100%. I know it's very difficult for me to convince the government now, but I want to make myself clear. Yes, let's hope the government will go back and think about this. Mr. Chen Kapil. Thank you, Chairman. It's a similar question to Ms. Sithol's. Just now we talk about insurance policy. I think we really have to look at that. The government has a number of assistance schemes, and insurance policy would be taken into account under all these assistance schemes. But that is really very difficult for the grassroots. So I hope the government can think twice. Now let us look at an applicant. Now maybe he's over 60. He's not working anymore. His spouse is working. He has an MPF account and he's retired. Theoretically, he can make an oath and he can get all his accrued benefits from the MPF scheme, but he hasn't done that. Or if he's over 65, he may still keep some of his money in the MPF account. So would these amounts of money be taken into account during the assessment? And what if he remortgage his property? If he gets hundreds of thousands of dollars for his remortgage, so this is a loan, would that also be taken into account during the assessment? LED. Mr. Tang, if this person is over 60, under the present law, there is already a deductible amount, which is equivalent to LASFEL. That is $269,620. In 2011, we amended the scheme. Is it section 14? Yes. If you are over 60, first of all, we would already provide you with such a deductible level. That is the OLASFEL, and now is set at a level of $269,620. So after deducting this amount, if his resources so exceed the FEL, but if it is a human rights case, or it is a case involving ICCPR, then the ceiling would be adjusted upward further. I still don't understand. For a person who is over 60, if he has financial resources of $520,000, then he can still get legal aid. Though if that is the case, I would deduct 269,620 from 520,000, and if the remainder is still within the limits, then he can get legal aid. That means for his financial resources, you would treat it more leniently. Yes, if an older person is of a certain age and he has some savings, we think that we should treat him in a more relaxed way. So in 2011, we already made this change. That is, when we assess his financial resources, we have added one more deductible item. So how about MPF? Even though he's entitled to withdraw his money, so he wants to leave that money in the account, what will happen? Well, yes, he is entitled to retrieve that amount of money. It's just that he's not taking it out. So we have to take it into calculation. Okay, if he's 65, he doesn't have to do anything. Even though he's still working, he's entitled to withdraw his accrued benefits. What if he's 60 to 64? So he has to make an oath, and then he can get some money. So for this age group, in the law, he is not entitled to withdraw his accrued benefits. He has to vow and say that he is retiring, and then he can get the money. So what will happen? We will have to ask him, will he be taking the oath so that he can get the amount of money? If he does not, what's the reason? So we will have to look at each and every case independently. But if you just say that he has this amount of money, he has to make an oath, and he is not taking this sum of money out, then we still have to get more information from him before we decide as to whether this amount of money would be assessed. This is under the OLAS. So for your frontline staff, they will pay particular attention to this group of people between the age of 60 to 64, and they will ask him about MPF. Well, when they apply for legal aid, the applicant would have to give us all the information concerning his financial resources. So we will consider which part of his financial resources will be considered. Now, the MPF SO will be amended. That is, you can withdraw your accrued benefits if a doctor certifies that you have a remaining lifespan of less than 12 months. What if he has a car accident and he's going to die soon? Maybe he's not even 60. So will you take the initiative to ask him to take an oath so that he can withdraw his accrued benefits? How are you going to deal with the early withdrawal after the amendment? Yes, that has just been approved, and we will look at each case independently. Well, this is quite rare, actually. Our frontline staff, if they notice this kind of case, they would ask the senior management for an instruction, and then we will consider the case very carefully. How about remortgaging a property? Now, if the aided person is living in the property itself, it will not be counted. But if the property is remortgaged, then that sum of money would have to be taken into account. However, he has to repay the mortgage every month, so that would be a deductible item. I don't understand, because you are looking at his financial resources in the past 12 months. So half a year ago, he remortgaged his property, he got 1 million, and he will be repaying that amount in 60 months. So for that 1 million, it will be his property. And then if he has repaid for 6 months, then that will be deductible. Now he has taken that sum of money. We would know that that sum of money is in his account. So when he comes to apply, we will have to look at the balance in his bank account. Now, because he's remortgaging, then each month he would have to repay. So when we assess his financial resources, we will know that he's repaying mortgage every month, and that can be deductible. That is how we do it. But for that amount of money resulting from remortgage, we would also take that into consideration. That is, when you make the application, what's the balance in your bank account? So the repaid amount will be deducted. Now, each month you would have to repay a certain amount, so we will be deducting that, and we will multiply it by 12, because the mortgage repayment is one of the deductible items. So the logic is, if I borrow $1 million, I do not repay $1 million. I repay $1.2 million because of interest. Then I would have to pay more.
We'll look at how much repayment per month to the bank. We would not work on the basis of the $1 million. Bank A provides the mortgage, and he goes to another bank or the finance company for more mortgage. How do you calculate it? Basically, if you have mortgaged your flat, how much deductible would there be? Normally, it would not be 50% of your salaries. But of course, there may be discretion that can be exercised. Okay, unless you have any further questions, and let's move on to the amendment regulation itself. Legal advisor, we don't have any specific comments. I've read the amendments. In fact, the Deputy Secretary has already explained them. Perhaps you might like to walk us through them once again. Madam Fong. Clause 1 is about the commencement date. The 17th of June will be the commencement date. Number 2 is about the amendment of clause sections 3 to 7. And number 3, regulation 2 to be amended. We add the financial eligibility limit. Means the amount of financial resources specified in section 5.1. Number 4, regulation 8A amended. Repeal everything after exceed and before and less, and substitute 12.5% of the financial eligibility limit. We would that there will not be any contribution payable unless there is any evidence to show that one has gone beyond this limit. Number 5 is regulation 14 amended. Contributions under the supplementary legal aid scheme. Under the SLAS, there is an interim contribution payable, and that is 10% of the asset or the maximum contribution payable, whichever is the highest. Number 6, Schedule 2 amended, rules for computing disposable capital. We repeal that specified in section 5.1 of the ordinance and substitute the financial eligibility limit. And that's in relation to those aged 60 and above. We would deduct the first sum of FEL. Number 7, Schedule 3 amended. That is to express the sums in percentage terms instead of in absolute dollar terms. Any questions? No? Secretary, please. After the scrutiny, on Friday, we will submit a report to the House Committee. This will go into effect on the 27th of May. There will not be any extension. We have specified that it will go into effect on the 17th of June. All right. I don't think we need any further meeting because we don't have any further questions. Anything else you'd like to add? Okay, then thank you very much for coming.